First, I wanted to start off by saying Happy Easter to everybody, Happy Passover. If you're celebrating those holidays this weekend, I hope you have a great time with your family and friends. Just some introductory remarks. My name is Beth Mulcahy, and I'm the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. Welcome to our First Friday, live virtual First Friday event for the month of April 2026. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also serve on my HOA board and have for many years. This is how First Fridays is going to work today, in case you're new to attending First Fridays. If you haven't already done so, please submit your First Friday question in the Q&A box on Zoom or in the comments section on Facebook Live as soon as possible. And then I will answer all questions between now and 10 a.m. I understand that unfortunately, I can't have this on Facebook Live today because we had a little technical difficulty, so I'm so sorry. I'm not quite sure how to fix that, but we'll just have to roll with it today. So sorry about that, that we're not going to be able to broadcast that. Maybe what my team could do is put on Facebook Live the link or some information on how people can join on First Fridays on Zoom. Just say that there was a technical difficulty this morning, and we're sorry that happened. Okay, let's go back over again. Sorry, got a little sidetracked there. Here's how First Fridays is going to work today. If you're joining us on Zoom, which is the only way we're doing it today, please submit your First Friday question in the Q&A box, and then I will answer the questions between now and whenever we finish, hopefully around 10 or 10:30 this morning. Just a quick friendly reminder, because we get a lot of questions, we have to limit it to one question per association. And if you plan on submitting a question live today during the seminar, please include your name and your HOA name and your current role when you're submitting the question. And also try to really frame the question in a short manner because we have a lot of questions, and it's hard when I get a question that's like 10 sentences long. It's hard to condense it and be able to answer it quickly. Okay, we're going to get started with our First Fridays today. As you may know, I always do kind of a little bit of a update on what's going on in the legislature every time I hop on and do a live seminar. So today we're going to be talking again about what's going on with the Arizona legislature right now. As you probably know already, we have a seasonal legislature in Arizona, and our legislature typically meets between January and June every year. And so we're kind of right in the thick of it right now with the Arizona legislature. There have been a number of bills that have been introduced this year, over 30 bills pertaining to HOAs and condominiums in Arizona. We are carefully monitoring all of these bills on behalf of associations. And our website has a great link that can provide you with information on all the bills. So if you go to our website at mulcahylawfirm.com, we have a link on the homepage of our website that indicates it's a summary sheet of all the bills that are pending. We just updated it as of yesterday to include the most recent information about how the bills are progressing through the legislature. There are a number of bills that have passed either the House or the Senate, but there are no bills as of right now that have been signed by our governor. So if you're interested in following the legislature this year, I encourage you to take a look at the information that we're going to be sharing with you on the Zoom comment section, which is our summary, or you can go to our website at mulcahylawfirm.com for an update. Okay, let's get right into our questions this morning. Our first question is from a board member, and we have 40 questions, it looks like. Just doing a quick little check. Yep, 40 questions as of 8:45 this morning. So our first question is from a board member. We allow free exclusive use of our clubhouse and pool for private events by homeowners, residents, and tenants, requiring proof of insurance for groups over 10 people. Since this homeowner is responsible for the actions and behaviors of their residents and tenants, should they be notified of a request, give approval, or maybe even make a request for the use on behalf of the resident or tenant? So great question. This owner is renting their unit or has a guest staying in their unit, and your association allows private events. And so, whenever there's a private event, you have a specific procedure that whoever's using the clubhouse needs to follow, including proof of insurance if you have groups of over 10 people. So my best advice for you on this would be the owner is the person that should be making this request. And the owner should be providing the proof of insurance on behalf of the resident that's the non-owner or the tenant. And I think that should just be a policy that you put in place going forward. Okay, next question is from a committee member. When a homeowner submits a compliance report because they've been identified as having a violation, is it required for the standards office to provide the reporter with the details of the outcome of another homeowner's property? Okay, so this question's from a committee member, and we've got a homeowner that's complaining about another owner's violation. Do we have to provide the person who complained about it a summary of what the board or the committee did, depending on who's enforcing it? So no, you are not required. The association is not required to do that. Most of the time I would say associations do not do that. They just thank them for providing us with the information, and we will be looking into this. Okay, next question is from an owner. My question is, and this is question number 3. My question is regarding the board meeting agenda that must be published 48 hours in advance per ARS 33-1804D. Our management company publishes a generic agenda, the same one for every meeting, and says this complies with their legal obligation. They then amend the agenda with additional topics just before the meeting begins. To me, this violates the intent of ARS 1804F, which means, you summarized it there, the agenda, providing the agenda 48 hours in advance, informs the members of the matters to be discussed and decided. What do you think? I agree with you. I think that there should be a new agenda posted with details that are more specific 48 hours prior to every meeting. Now, that being said, there are things that come up at the last minute all the time with associations. So you can't fault the management company if they add some things in that 48-hour period window before the meeting. That is very common. Typically, those things are going to go under new business or old business. Also, that being said, we typically have the same agenda backbone or structure for every single meeting. So, it's going to be pretty much the same things for every meeting, right? You're always going to have like approval of last month's minutes and the president's report, the treasurer's report, maybe the manager's report, old business, new business. And so those categories will always remain the same, but the little subcategories under those categories, they should be changing. Generally, a few of them should be changing every month, and those changes should be put out at least 48 hours in advance of the meeting with the agenda and the notice. Okay, next question, number 4, is from a resident. We are a gated community. Recently, a few residents asked the board to add painted crosswalks, stop signs, and other items to enhance safety for pedestrians. Other residents say these things ruin our aesthetics in the association and people will ignore them anyways. Must we add these things if they are unenforceable? What is the minimum we need, and how do we protect our HOA from any lawsuits due to pedestrian injury? This is a really good question. And I have a cheat sheet that I think could be really helpful on this. I think it's called Speeding. I think it's Barking Dogs and Speeding in an association. It's kind of a code cheat sheet. And I guess my thoughts on this would be, I think your board needs to do a little research before you would ever implement, crosswalks, painted crosswalks, or, speed bumps, that type of thing, or stop signs. You may also need to check with your city, town, and municipality to see if there are any special requirements. There probably aren't because you're gated, but you would want to double check, of course, before you do that. What I would recommend is there are companies that will come out and that will do a traffic assessment in your association and give you recommendations. And as part of that, what they will typically do is they'll bring out like a speed trailer. and they will put that up in different areas in your association. And they put like a little black cord across the road to see which roads have the most traffic across them. And, they'll interview if you have security detail or, a gatehouse, they'll interview and find out if, there's issues with speeding, etc. And they'll interview the board too to find out what kind of complaints there have been. And then what I would recommend is look at the issue with that particular expert and come up with a plan that is going to be beneficial for your community. You may not need to have any of these things, or you may need to have a few of them implemented. And that way we limit our liability as a board, and we're not just making a decision, no, we're not going to do this, or yes, we're going to do it, and then, alienate all the homeowners if they don't want it. I think the best approach would be bring in an expert, have them give you some advice after doing some factual research, and then roll out like a good communication strategy to your homeowners, explaining that we brought this expert in, and these are the recommendations, and therefore we're going to be implementing these things, and give them a timeline for the implementation, and discuss all of this obviously at an open board meeting, and vote on all this at an open board meeting. And I think that is the best way, in my opinion. I see you're a large association, and I think you have the resources to do something like that. Okay, next question is from a board member, number 5. How do you deal with a board member who doesn't want to talk about solutions and just wants to talk about how every idea is the wrong idea, but also has no ideas? This track has caused inaction and confusion among the board. Oh boy, does this ever hit home for me. We have a situation like this on my board, and it's been going on for a decade. So I'm very tired and weary from this situation. So I really do feel your pain. A couple of things to think about. So what's the best manner to handle this person? Try to get good candidates to run for your board, so that when this candidate is up for reelection, when this board member is up for reelection, maybe they might be outvoted by somebody who is going to be more progressive and who's going to want to contribute more to the community, other than just saying, this is wrong, we can't do this, this is too expensive, whatever. So try to get good candidates to run for the board. If this is crossing over into this is affecting the dynamics of the board, or this is potentially negatively impacting the association because we can't get anything done and we have a lot of problems in our association, your board may want to consider whether or not a removal petition is something that we should examine, for the removal of this board member. Now, I would advise against the board actively trying to remove another board member, but if other owners want to, start a petition for that, and the board shouldn't take any sort of official position on it. Of course, if you agree with it, you can sign the petition, and go through the removal process, which is outlined under Arizona law. Another suggestion, if you have a difficult board member like this, is for somebody on the board, hopefully the president, or maybe the association's attorney, to talk with the owner and find out, what's going on. Are they wanting to continue on the board? Why are they only putting up, roadblocks and never coming up with any solutions? And is there something that we can do to try to turn this person around? Or is there something that we can do? Or is there some way that they feel that they've been wronged by the board and that's why they're behaving like this? Open up the lines of communication and see what, that happens. Now, in my experience, when we tried to do that communication thing, it didn't go very well. Sometimes there's an issue of mental illness, or control issues with these people. And so it can be a difficult situation to navigate. If you are unable to do any of those things that I have given you and you're just kind of stuck with this person, some suggestions on how best to deal with them is just keep moving forward. Try to build a coalition of a majority to get things done, and recognize that this person is just a negative person and they don't want to see progress, and limit discussion at board meetings to like 1 minute on topics for each board member. Therefore, you only have to listen to all the negativity for a short period of time from that person. You don't let them railroad the meeting and start filibustering for whatever cause that they have. So hopefully that will give you some suggestions. This is a common problem, unfortunately, and it's just one of those, things that you have to manage when you're serving on your board. Okay, next question, number 6. Can we share our condo association members' email addresses and or phone numbers with everyone in the association? We used to put a list of all unit owner names, addresses, and phone numbers on a list and include it in the yearly members meeting packet. So a really great question from an owner. You have to be a little careful about disclosing individual owners' emails and phone numbers without their permission. So it is public record, the owner's name and their property address for the association. That's public record on the assessor's website for whatever county you live in Arizona. But having their phone number and their emails, that's private information, and I would advise against providing that to all of the other owners unless the owner has consented to have that information provided to the other owners. So, I think that if you're going to do this or have like a little buzz book where people can call their neighbors or have access to the neighbors, I would have a box that people check that indicates that I am okay with the association using my email or my cell phone or landline in the official membership directory for the association so that there's no invasion of somebody's privacy. Okay, next question, number 7, is from a board member. We need help adding a statement at the bottom of the architectural guidelines that states only what is being requested is allowed. We have had a problem with people adding changes not requested and thinking that they can do that. How should we go about that? Okay, so this is from a board member, and you want to add a statement to the bottom of your architectural guidelines stating that only what's being requested is allowed. It sounds like people have been just making changes without getting permission. I don't know how your architectural guidelines can be officially amended or changed, or if it's just something that the board can promulgate. Oftentimes it is. So I'm fine with you, reiterating that language. You might want to just refer back to the language in your CC&Rs that requires architectural approval for any, changes to an owner's property, whatever your language specifically says. So I think that I'd have to give you a more definitive answer on this. I'd have to look at your CC&Rs to see how the architectural guidelines are promulgated and then help you write the language on that, but I think it can be done. Okay, next question is from a board. For an outgoing board transition after the annual meeting, can its minutes be approved by the new board, or should its minutes be approved only by those board members of the former board, with the new board members abstaining? This is kind of a tough question because I get it. You have every year there's a transition in the board typically, and at the first meeting after that transition where the new board members come in, the minutes from the last meeting are going to need to be approved by the new board. And several members of the new board that were just elected weren't at those meetings. So I don't think there's any like hard and fast rule on this, in my opinion. Those owners can abstain if those board members that are newly elected can abstain if they, want to. Or they can also approve it if everybody that was at the meeting says, hey, this is reflective of what happened. The board members, I'm fine with voting yes to approve them as a board member. So I don't think there's any right or wrong answer on that. If you don't feel comfortable doing that because you weren't a part of the board, just abstain. The one risk that you run is that if there's been a majority of the board that has turned over, we'll never get those meeting minutes approved from the prior meeting unless we have, a majority vote. So it can be a little bit problematic if you don't have that, if there's, majority turnover of the board. Okay, next question, number 9, from a board member. 2 directors overreached their positions, potentially causing the HOA a lawsuit. As individuals on record, they approached Maricopa County Permit and Zoning, it sounds like, without board approval, creating these problems, not disclosing writings or answers to the board. One permit was delayed at HOA level months, and another permit building is now non-conforming or non-compliant. Did they violate Arizona state statutes or code of directors' conduct? Should they resign? Let's see here. HOA appears to be suffering consequences of their individual actions, although directors. Okay, so let's break this down. This looks like kind of a complicated question. So it's from a board member, and it says two directors, in your opinion, kind of are causing the HOA to get involved potentially in a lawsuit. And apparently they approached P&Z. So I'm not sure. I'm guessing that it's whatever county that you live in that they wanted to get a permit for some sort of a change to the property. And they did this without, the board knowing that they were going to do this. Well, that's kind of problem number one. You shouldn't be pulling a permit or filling out paperwork for a permit for the association to take some sort of construction action unless you have the support of the board. So that would be problem number one, okay? The permit was delayed and at the HOA level for months, and another permitted building is now non-conforming and non-compliant. Okay, so it's hard for me to piece together because this is a little confusing on this question, but it sounds like you have overreaching of actions by two board members, and they are taking steps without approval of a majority of the board, it sounds like. And now they've gotten the association in a pickle because it looks like they may have built something and they don't have the proper permit. I definitely think you need to get your attorney involved and strategize on this right away, in terms of, are we going to proceed forward with the construction project? If we are, we probably need to go back and get board approval, number one, and then figure out the issues that are in violation with the city or the county. But this is definitely a serious issue. I do think that these board members, need to recognize that they've made an error and we need to get this back on track. So reach out to our firm if you want help resolving this issue. Okay, next question, number 10. Let's see, is from a manager. Okay. Let's see. I know my office is giving me a notice, but I'm sorry, I don't know how to do that. So I apologize. I guess there's somebody in the waiting room and I'm not quite sure how to do that. Let's see here if I can let them in. Sorry, technical difficulty day today. So sorry about that. If somebody's in the waiting room, we'll make sure to post a notice on there that this video will be available shortly on our website. Okay, let's see here. Okay, let's just go on to the next question, which is question number 10. Our ad hoc, and this is from a manager, our ad hoc committees that don't meet regularly subject to the requirements in the open meetings law, such as 48-hour posting and keeping minutes. So short answer on this is, in order for the open meeting law to apply to committees, you need to have, the committee would have to be having regularly scheduled meetings. And that means like they always have a meeting on the first Friday of the month at 9 a.m. Your particular ad hoc committee that you're mentioning here does not meet regularly. So it is not subject to the open meeting law and is not subject to 48 hours notice of the meetings and, having an agenda at the meetings, etc. But my opinion is that ad hoc committee should be taking minutes. So that is something that I would, it's a requirement in my opinion, because we have to show what was, being discussed and decided by the committee, and then they report back to the board with that information. Okay, what to do when our next question, number 11, from a board member. What should we do when the architectural committee members and chairperson are exceeding their authority and going outside of the governing documents? For example, making decisions based on city's land development ordinances and not on the CC&Rs or bylaws requirements or rules and design guidelines as specifically outlined in the documents. Okay, so this is from a board, and it sounds like you've got an architectural committee that is potentially, going off the beaten path and violating what your documents say. So Remember that a board member has to be a member of the architectural committee under Arizona law. So, there should be one board member that's in there, and that person is the chair. And so hopefully your association is complying with the requirement under Arizona law to have at least one board member that is the chair of the architectural committee. And so I'm not sure if that's happening here or not, but maybe you need to appoint, a new committee. Maybe you need to change the chair to a different board member. But the association's architectural committee, their responsibility is outlined in the CC&Rs, and they have to comply with the CC&Rs and the other documents for the association, such as the rules and the design guidelines. So I think, whoever the president of the association is needs to talk about this with the current architectural committee. And if this isn't resolved immediately, we need to think about maybe removing the chair and putting in a different board member, maybe getting the association's attorney involved to make sure that whatever prior things that they may have approved, we have to discuss how that's going to be handled going forward, and drawing a line in the sand and saying, okay, starting right now, we're going to be doing everything consistent with what our documents state. And, we're not relying on, what the ordinances or the city codes state. We have more stringent requirements typically with CC&Rs and architectural guidelines, and those need to be upheld by the architectural committee. And if they're not, then we may need to change the chair out, or we may need to change the entire committee out. And the board, we have to look at your bylaws, but typically the board's going to have the authority to do that. Okay, next question, number 12, is from a board member. Corporate records were scanned and removed from our storage room, destroyed by the former management company in November 2024. No board member was present with the property manager. Rose Garden has no inventory of what was stored. No written board authorization for the property manager to act. Stored records contained privileged information. No guarantee proper disposal methods were used to protect the privacy of owners. What is the best course of action moving forward with the new management company? Okay, so it sounds like your board had all of your corporate records that were scanned, which is kind of what most associations are doing now. They're putting everything into electronic format and storing it on the cloud. And so it sounds like the actual physical copies of these records, were taken by the former management company, and they, we don't know what happened to them. We don't know if they were shredded, and you're worrying about that. Obviously, this has been a couple of years now, or a year and a half at least. So I would say, not much we can do about that situation. But going forward with your new management company, you should ask them, what is your procedure internally, with the bank statements that come? Maybe they're, if you're getting a hard copy of the bank statements for your association and they're electronically storing them on, the cloud now, what happens to the actual paper bank statement? And make sure that, there's an agreement in writing that the documents that are sensitive are being shredded, etc. Okay, next question, number 13, from a board member. Our community identified a need to fix some sidewalk tripping hazards. We are planning on doing it in 7 weeks because we currently are painting all of our townhomes and it's just too much activity going on. Our management company tells us that we are not allowed to delay and we need to do it immediately or must notify our insurance broker about the delay. Is this necessary? Okay, so we've got some tripping hazards on sidewalks in the association, and we're going to do it in 7 weeks because we've got another project going on, painting our townhouses. Management companies telling the board, hey, you got to do this right now because this is, they're upset about it, right? And they're claiming they're going to notify the insurance broker about the delay. Now, I'm not sure if the insurance company is requiring this. If the insurance company is requiring it, then you really do need to do it. If the insurance company isn't doing it, requiring you to do it, you may be able to get away with, putting cones in these areas or painting it like a fluorescent color, putting some sort of, paint that is visible even when it's dark out. It's not that difficult to deal with the sidewalks. Usually you bring in a company and they grind them down and it's no big deal. I don't know how many you have that are problematic. But I'm kind of with the management company. I really do think you need to move on this because we monitor the cases that are filed every day in Superior Court, in every Superior Court in the state of Arizona. And really some of the most common cases that we see being filed against, or lawsuits being filed against associations, are for trip and falls on common areas. And so this is something that where you could have some liability and one of your owners could be hurt. So I'm with the management company. I think you really need to get moving on this and have a company come in and take care of it. I know that it seems like you have a lot going on right now, but you can delegate this to the management company and they can bring in a third party. And usually these things can be resolved in a couple days, depending on how many sidewalks that you have that need to be fixed. Okay, next question, number 14, is from an owner. If your committee meetings are called at will, do they need to be noticed? And is there a limited number of unit owners that can be on any committee? So we kind of answered this question already previously about committees, but I'm just going to do a quick reminder. If it's a regularly scheduled committee meeting, then you are required to comply with the open meeting law. And so I don't know if this at-will committee is one that meets the third Thursday of every month at 7 p.m. That's going to be a regularly scheduled committee meeting, and you would have to follow the open meeting law. If it's not, you don't. How many people can be on the committee? It's up to the board. My feeling is enough so that the board can, work effectively together. Sometimes having, 20 people on a committee makes it harder. It depends on what the task of the committee is. And, if you're having a community-wide huge celebration for like a 25th anniversary for your association, and it's a huge event where, a lot of people are coming and there's all kinds of different tasks, and a big committee may work. If you're amending the CCNRs, I think a committee of 20 is going to be too many people. So I think it really just depends on what the committee is tasked to do and what's the most effective number. You can always reach out to me and ask me what my opinion is on something if you're not sure. And really the board makes a decision on how many people are on the committee. Unless the documents require a certain amount of people, then you would have to go with what the documents require. Okay, question number 15 from an owner who is also a former board member. Let's see here. Okay, we have not had any minutes reported for almost a year. There's been one budget meeting, one annual meeting, 3 normal meetings, and only 1 executive meeting. I'm told that meeting minutes have to be ratified by the board. The board does not review and ratify minutes at subsequent meetings. Is this an open meeting infraction? So no, the open meeting law doesn't require associations to take minutes, but this is going to be like a fiduciary violation. The board needs to have minutes to reflect what the decisions of the board are. And so if they're not taking minutes, or if they're taking minutes but not ratifying them, they're not following the corporate procedures that are necessary for an association. And so I would encourage you to talk with the board and find out, are you taking minutes, and remind them of the requirement to ratify the minutes at the next meeting where the board is meeting. The annual meeting minutes obviously don't get ratified until the next year's annual meeting. But this is a corporate formality that needs to be followed. And if they aren't doing it, in my opinion, they're not living up to their fiduciary responsibility, the duty of care that's required, and their fiduciary responsibilities to the association. Question number 16 from a board member. Is there any value in having community volunteers fill out a waiver of liability form when doing work in a community? So great question. Do waivers, for work that members are doing in your community, is it worth it? So first things first, be really careful. You shouldn't be having committee members, you shouldn't be having community members who are volunteers like jackhammering the pool deck at the pool. that is not something that, in my opinion, is a task that volunteers should be doing, right? Or tree trimming high trees, or climbing up on a roof to fix a roof repair. So first things first, no activities by volunteers that are inherently dangerous or that require some sort of specialized knowledge. If you're having volunteers like do a trash pickup day or something, having a waiver is not a bad idea. Our firm can give you some sample waivers if you'd like it. However, recognize that people really can't waive their rights if something happens when they're, doing the trash pickup. So it is something that we would use as a deterrent for people to sue us. Like they might be thinking, oh, I signed that waiver and I gave up my right to sue the association. But when, it really comes down to it, that waiver isn't going to stand up in a court of law if challenged. So it is a step that you can take if you want to. It is a deterrent to the association being sued, but ultimately, it's not going to stand up in a court of law. And remember, don't be careful about what you're having volunteers in your community do. You should be hiring licensed and bonded contractors to handle any, cleaning the pool or, any task that requires you to have somebody that has, knowledge in that subject matter. Board members, shouldn't be, or board members or volunteers really shouldn't be doing things that are inherently dangerous or things that, require, you should be hiring like a landscaper to do landscaping, not having homeowners voluntarily doing it. Okay, next question is number 17. We have an established fine schedule for parking violations. After notice and opportunity to be heard, is a motion in the open board meeting necessary to assess the fine? So yes, there is a procedure under Arizona law that you are required to follow. So you have to give notice of the violation, step one. You have to provide in that notice an opportunity to be heard. So the notice is going to have to say, you have violated the association's parking rules by, parking on the street or parking on the grass in front of your house. And, we have proof that you did this on X date, and this is a violation of section blank of the CC&Rs. And if you dispute this violation, you can contact us by sending an email to us or sending a US mail letter to us and give them, 10 days or whatever it is, 5 days, whatever you think is reasonable based upon what the violation is. And then after that time period expires, then the board is going to have to vote on it at the next board meeting they're going to review the response and decide, are we going to fine them or not fine them? If you are going to fine them, you have to make a motion, have a second, maybe some discussion on it, and then a vote by the board. So short answer is yes, you do have to make a motion and have a second and then approve it. A majority of the board would have to approve it. Okay, question number 18, looking for direction on what to do for an HOA who cannot get records from their annual meetings. Probably they're waiting for the minutes from the prior year's minutes for the annual meeting. If we have legal send a letter to the prior management company, what is the likelihood that we get the documents? And what if we don't get anything after the demand letter? And approximately how much does that demand letter cost? Okay, so great question. And actually, interestingly, this is from a management company who's asking about not being able to get records from the association's prior management company. So in my experience, when we have a management company that is either refusing to provide the records to a community that they formerly managed, having the attorney write a letter and pick up the phone and contact the CEO of the prior management company and request the information is a very effective tool to get them to comply with giving you the records. Also, it's going to give us some closure because they might say something like, well, here's what happened. We had that manager for the association. That manager quit. The manager never did the minutes. And we don't have minutes to provide to you. So at least we have closure on it, right? Now we can go back and try to recreate those minutes as best we can based upon whatever records we may have from that meeting. Or they have them and they just send them over to us and the matter is finished. So yes, I think it's a great idea to have the legal counsel do it. If the new management company has been requesting and requesting, and the former management company is just blowing them off, getting legal counsel involved, writing a serious demand letter, and picking up the phone and calling the CEO of the former management company is a great tool to get this done. The approximate cost, probably in the $200 to $250 range for legal fees. Okay, next question, number 19. We actually had to combine this because there were multiple questions from this particular owner. So we had to condense and combine a little on this one. What is considered a typical or appropriate level of HOA reserve funding? And does being at 145% funded in the reserve indicate overfunding that the board should address? If reserves are overfunded, should the board consider adjusting the contribution, such as reducing the reserve allocations or assessments? And is there any liability for not taking action? So this is a good problem. Like, we never ever get questions like this where the reserve is this much overfunded. So a couple questions that I would be thinking of if I were advising your association. So number one would be, have you had a formal reserve study done by a company that specializes in, and is licensed or, has a proper credentials to provide you with a reserve study? So if the answer to that is no, then I think you really do need to get a reserve study that's going to be accurate and that's going to tell you how much you really should have. If the answer is yes, then our next step in the analysis is, okay, we used a professional reserve company. It appears that we're overfunded, because we're at 145% funded, and, most associations, their goal is 90 to 100% funded. Yes, I think the board needs to have a discussion about this. Maybe bring in your attorney, talk about it with your management company. And do we need to continue putting as much money into the reserve every year? Or do we need to take a year off to kind of balance it out? And we got to analyze the numbers and determine, how do we get this to the sweet spot, which is going to be like 90 to 100% funded? And I think there needs to be some analysis done by the board, the management company, your attorney. Maybe the reserve specialist should come in and give you a little advice. Maybe your reserve study. They have one page that lists the 30-year contributions and how much money you need each year, in the reserve to meet the expenses for long-term capital improvements that need to be done that year. Maybe it's time to get that reserve study updated so that, we can reallocate how much money we should be putting in there each year. Okay. Is there liability for not taking action? I mean, probably not, because I think the board is likely acting in the best interest of the association. They just need to fine tune this because it's overfunded. Or maybe they need to do some major renovations. They're just behind on, capital improvements, and maybe they're planning to spend all this in the next year. So all these factors need to be, evaluated. Next question, number 20 from board. Should an association accept a bid for a repair project from the company of a homeowner within the community? This is an unsolicited bid when bids went out to other contractors. Is this a conflict or against best practices when this is a homeowner who lives within the community but owns the company that is bidding? Okay, so this is, I love this question because this happens all the time. And it can be very problematic. So we have an owner who owns maybe a construction company, and we're planning to, renovate the clubhouse. And this owner hears about it and submits a bid, unsolicited. I think that the board should thank the particular company that submits the bid, but I would not consider that bid for a number of reasons. A, it's unsolicited. You're not required to. B, it's never a good idea to hire a company that has as its, one of its directors or members or, somebody who lives in your community, because a lot of things can go wrong. And if something goes wrong on a construction project, now this person lives in the community, the other owners may think that there was favoritism given to this owner, or maybe if there's problems, now everybody in the community is mad at this owner, or the owner's mad at the association's board. It's a nightmare. Don't go there. Please. I've seen this unfold in other associations many, many times. So I would say, as a rule of thumb, best practices is do not do not solicit bids from, and do not hire homeowners, companies to do work within your association. It's not necessary. And sometimes the association's looking to save money by doing this, and it's not a good idea. It ends up costing more in the end. Okay, next question, number 21, is from a board. Under Arizona Revised Statutes 33-1809, does the statutory protection apply to an unmarked vehicle? Only a paper play card, no government plates or permanent agency insignia used by a resident who claims they have employment with the Arizona Attorney General's office, or is the exemption limited to vehicles that are both agency owned or operated and bear an official permanent emblem? Okay, so and my office is amazing. They cut and pasted this right into my computer so I can look at the statute right away. So this question deals with public safety and public service and public safety emergency vehicles. And so apparently the question is, you've got somebody who lives in your association, a resident who's relying on this law to be able to park their unmarked vehicle on the streets of the association or the driveway in the association. So a couple of thoughts here on this. There is a law that prohibits, or that says an association shall not prohibit a resident from parking a motor vehicle on a street or driveway in the planned community if the vehicle is required to be available at designated periods at the person's residence as a condition of the person's employment. But they have to be employed by specific state, organization. So a public service corporation that's regulated by the Arizona Corporation Commission. Also on the federal level, an entity regulated by the Federal Energy Regulatory Commission, or a municipal utility, and the Public Service Corporation or municipal utility is required to prepare for emergency deployments. So, I guess there's a whole, list of categories of people, but, it's basically, there's also like a weight, has a gross vehicle weight rating of 20,000 pounds or less. It has to be owned by the Public Service Corporation and the municipal utility, and it has to bear an official emblem or other visible designation of the Public Service Corporation or municipal utility. Okay, so your in case is they're employed by the Arizona Attorney General's office. I'm not sure that is going to fall under this. I don't know specifically what this person's job is. It's not police or fire service, or ambulance service, which is another, carve out under the law. So I guess what I would do on this, I'd have to see specifically what the play card says, and find out more about what this person does for the Attorney General's office. I don't think that this is going to be something that's going to fall under the statute, but without seeing everything myself, I don't want to give that final determination, but it doesn't look like it does based upon what you're telling me. Okay, question 22 from a board member. This is a hypothetical question. If a director has a private discussion with their neighbor about an open architectural request, the director indicates this is likely going to be approved. The director begins to persuade or coerce the architectural committee or design review committee to approve, rather than allow the board to discuss the issue during a possible appeal. Director and the DRC chair, who's a board VP, discuss possible impropriety and have come to an impasse. How does a board address a president who actively attempts to persuade ARC decisions on behalf of their friends? Can the committee chair dismiss the influence? Ooh, this is a good question. So first mistake, the director, it sounds like it's the president, talks to a neighbor about an ARC request. That is a big mistake. Don't do that. As a board, don't get trapped into talking about somebody's proposed project with an owner. It's never a win situation, ever. Sometimes the owner will claim that you said it was approved, and now we've got an issue of whether there was apparent approval based upon the discussion. People walk away from conversations taking away different things from it, and maybe the director thought, oh, I just looked at the project and said, that looks pretty. And the owner looked at it and said, hey, they approved it. I'm going to go paint my whole house the color. So mistake number one, no board member should be individually meeting with an owner to discuss a potential construction project, painting project, any sort of thing that requires an architectural committee request. So that was the first mistake. The second mistake is allegedly the president is pressuring the architectural committee to approve something. That should never be happening. We all need to be fair and impartial and just uphold the documents. And the architectural committee has a job that they need to do. There's already a board member on that committee as the chair, pursuant to state law. So let this play out. You shouldn't be doing that. And so the committee chair, in this situation, may want to reach out to legal counsel to discuss this. It shouldn't be a vindictive disapproval because of the president's actions. You should independently review this and determine whether or not this is something you would allow or not allow. And I think your board needs a boot camp to talk about some of the dysfunction that's going on your board. Our firm does boot camps very regularly for boards to go over what your fiduciary responsibilities are, to talk about issues like this, to make sure it doesn't happen again in the future, and to just find a way to work together better and go over what state law says, go over what your documents state, and just have a refresher in 1 hour on how you can function better and comply with the law, comply with your documents going forward. Okay, next question, number 23, is from a board member. Our 40-home community has had a highly restrictive driveway parking restriction in the CC&Rs since 1979 and since the establishment of the association in 1985. This has been routinely violated by as many as 40% of the various homeowners over the years, and there's never been any enforcement or fines, with the exception of one homeowner who received a letter regarding a trailer in the driveway. Can this restriction be enforced now? Does waiver or latches apply? So I'd have to kind of hear more about the violations over the years, like when I see the section in the CC&Rs to see specifically how it's worded. And I don't know if, you're saying that it's been violated. I don't know how it's been violated. Are people, temporarily parking their vehicle there? Have other trailers been, stored there? So it's hard for me to comment on it until I hear more about the facts and read the provision in your documents. But, generally speaking, boards change and some boards enforce things more than other boards do. Because you allegedly have so many owners that are doing this, you may need to think about, is this something that we want to keep in our CC&Rs going forward? And maybe we should do an amendment to take this out. Or if it is something that you want to keep and maybe people have been parking, cars and trucks, but not trailers, and you want to continue to enforce the trailers, I think we have to take a close look at, has this section been, effectively, are we waived from enforcing it because it has been violated so regularly in the past? So lots of things to consider. At first glance, I wouldn't say definitively that you can't enforce this. I would say I need to hear more. Okay, next question, number 24, from an owner who is the past manager. Our HOA held an election for budget and amendment to the bylaws. Both issues were defeated. The board asked for the member again to vote on the amendment. After the executive meeting and the general meeting began, members were told that the ballots had been counted for an amendment defeated. Can the ballots be counted in executive session? Now they want a new vote on the budget. How should this be handled? The method followed does not seem transparent. Okay, so we have an owner who was a past manager asking this question. Your board had a vote regarding apparently approving the budget and amending the bylaws. Allegedly, both issues were defeated. Then the board, I think at the meeting, I'm not sure based upon your question, asked the members again for a vote on the amendment, maybe at a future meeting, not sure. After the executive meeting and the general meeting began, members were told the ballots had been counted and the amendment was defeated. I guess it's you're asking, can the ballots be counted in executive session? I mean, really, everything should be counted in the open meeting, the meeting of the membership where you're having the ballots. I do make an exception if you're a large association and we have a large turnout of absentee ballots. We typically will count those the day of the meeting or maybe the day before the meeting, just to make the meeting flow more smoothly. But it is kind of awkward and unusual to have an executive session within the meeting of the membership. That's not something that I've ever seen before. Now the board wants to vote on a new budget. How should this be handled? I think you need to get your legal counsel involved to determine, how to best handle this. So you have to pass a budget, and it's already, April for 2026. So you guys need some guidance on how you want to handle this. I would say that, if your documents require the budget to be approved, we have to discuss how the procedure to do that is. We need to look at your documents and just come up with a strategy. And without seeing your documents, it's hard for me to comment on that. Next question, 25, from an owner who's a past board member. Can a board create a policy requiring past, present, and future board members and committee members to save and store via paper and/or electronically all their HOA correspondence on personal devices? When the term ends, all records would be turned over to the board or property manager. This appears to exceed the legal retention periods detailed in your cheat sheet. Thank you. Okay, so your board has a policy. They want past, present, future board members to save and store via paper or electronically all their HOA correspondence. And then all records are turned over to the board or property manager. This is kind of a difficult situation because really there shouldn't be a lot of information on on a board member's personal device, right? Because you shouldn't be making decisions outside of a board meeting. So at first glance, I'm thinking, are there violations of the open meeting law going on here? I think it's an unusual. I serve on my board. I've been on it now for 14 years, and I have a paper packet that I get for each. I'm on 2 boards for each of my boards, and I am not required to give it back to the board. I shred it and toss it after the meeting. So I think this seems a little bit restrictive, and I'm concerned that why are you having a bunch of records on your computer, emails or whatever, because you shouldn't be making decisions outside of a board meeting. So I would say this is unusual. I would need to hear more about the justification for this. And I would want to talk with the board about whether or not, what they're doing is violating the open meeting law if they have a lot of records of their, communications regarding the association. Okay, next question. Number 26 from a board member. Our small satellite HOA board has 5 positions pursuant to our CC&Rs. We only have 4 directors right now serving. The master HOA board has only 4 of 7 positions filled. What number should be used to consider a quorum in these cases? Number of positions or number of serving directors? If it's the latter, doesn't that mean that 2 directors cannot discuss any HOA business without violating the open meeting law? What would you suggest when it's not possible to get people involved? Okay, lots of questions there. Okay, so let's just give a general example that you can apply for your sub and your master association. So if your board has if your documents say you have to have 5 members on your board, you have to look and see, what a majority of 5 is going to be 3, right? And in order to have a meeting, you're going to have 3 directors there. So right now you have 4 directors serving. It's kind of a difficult situation because if the vote falls 2-2, nothing happens. Status quo. Whatever you're voting on fails. If let's say you have a meeting where, you have 4 of the 5 directors there and, you have a quorum. So if you have 3 directors agreeing on something out of the 4, it passes. And so it goes by, the requirement, the majority requirement goes by the total number of directors that are required for your association. So that's going to be important to have a quorum. You needed to have 3 out of the 5, in order to have a quorum for a 5-member board. What do we do if we can't get board members? I know we've written a number of things on this in the past, so check out our website on this. I'm sure we've got probably like newsletter articles on this or Mulcahy memos that we've written on this. The best thing is start early before an annual meeting and send out a candidate request form, ask for people to fill out the form with their bio and why they want to be on the board. If after you send out a candidate request form, no one takes the bait, the board should talk about who would be some people that we might want to reach out to ask them if they'll consider to be on the board. And one way to do that is look at committee members, look at people who come to your board meetings. Look at your pool of candidates, your homeowners. The type of people that, are great board members are people that care about the community, maybe that have come to board meetings, that serve on a committee. Maybe they have some special expertise, like they're a CPA or a lawyer or a realtor or an engineer, interior designer, somebody that has time, they're retired, always are good candidates to be on the board. If after you go through that, you still can't, you reach out to people, they say, no, I don't want to do it, then we typically will recommend that you send a letter to the owners saying, okay, here's what happens if we don't have enough board members and can't even get a quorum of the board members. Our association may have to go into a receivership, and a receiver will be appointed to run the affairs of the association, which will cost everybody more money in assessments and also will not be good for property values and resale of properties. Okay, next question. Question number 27. The Arizona Open Meeting Law causes frustration and inefficiency among board members and committee members by lack of candor, spontaneity, fear of brainstorming. What are tools that can be used to make board members effective without running afoul of the law? So I honestly don't think that the Arizona Open Meeting Law should cause frustration and inefficiency. I kind of like it because it gives you one time a month where you go into the meeting, you're in the zone, you make decisions about your community. And then in the meantime, either your management company or your property manager, if you have an individual property manager for your association, is running the affairs of the association per the board's direction. What are some tools that if you want to get around the open meeting law, you can have less than a quorum of the board meet to discuss things? You still have to notice this is an open meeting, but you can have brainstorming sessions for your board. I don't think just because it has to be noticed and owners are allowed to attend, it doesn't mean they can interrupt at that meeting if it's just a brainstorm meeting and you're not taking any official action. And again, less than a quorum of the board can meet to discuss things and not be in violation of the open meeting law. Question number 28. I'm very interesting. I've had, I think, 5 or 6 questions from this particular association, which is very odd in one class. So got to be careful. I'm going to allow it this time, but this one association has asked a lot of questions this particular time. Okay, because of the change in ARS 33-1818, our homeowners voted to retain the ability to regulate public roadways in our association per the CC&Rs. Our public streets are owned and regulated by the city's traffic engineer. I have presented the question to the traffic engineer. So far, there's been no response. This seems to be a conflict between the state and the city. Our board is in the middle. How do you suggest we proceed? Let's see. So your board, I know you're a large master plan community, and your board voted, your homeowners voted to retain the ability to regulate public roadways. I think it's fine. I don't think there should be an issue about the city, traffic engineer owns and regulates the streets. I don't think that is a problem. I think you still have retained the ability to regulate, parking on your streets pursuant to Arizona law. So I'm not quite sure why your board is in the middle, but it sounds like you complied with the law and this shouldn't be an issue. Okay, next question, number 29 from a resident. Our HOA board is not doing a good job. They have recently replaced the prior long-standing board. and this is from a resident. Our current board seems to be overworked in meeting the requirements of the current division of duties between the board and community management company. What is the best way to assess the potential to redeploy duties while still keeping adequate oversight in the hands of the board? Okay, so it sounds like you're a resident in a condo association. This question kind of conflicts a little bit. It says, your board is doing a good job. They replaced a long-standing board, but you're overworked and you're struggling with the amount of work. So what's the best way to redeploy duties while still keeping adequate oversight in the hands of the board? So I don't know, maybe you guys are self-managed, I think, based on what I'm reading between the lines here. So I think you need to get some advice. It sounds like you're struggling a little bit, and I would reach out to your legal counsel and talk about what the issues are that you're struggling with, because it sounds like maybe you need to bring in a management company to help you handle some of the day-to-day affairs, because you're not able to handle all the duties, and you're struggling with that. So that's a possibility. I think just having a strategy call, even if it's like 10 minutes, hey, these are the problems that we're facing. Like, do you have any suggestions? As somebody who has worked with associations for 30 years now, or 30 years in November, I can tell you that I've seen a lot of different problems over the years, and I've helped a lot of associations. It sounds to me like, reading between the lines, maybe you need to get in a management company. If you don't have the funds to do that, then maybe we need to consider bringing in some committees and having some committees appointed to help you run some of the duties and responsibilities of the board. But I'd have to hear more about what you need help on to give you a good answer. Question number 30 from a board member. A lot is for sale. A 2020 inspection cited no CC&R violations. In 2024, the seller received notice of violations, so 4 years after the 2020 inspection report. The violations were structures were built without design review committee approval. All exceed the total square foot allowed for coverage in our association. A March 2026 inspection report cites all the same violations. The buyer says the association cannot require him to remove the unapproved structure since they've been in place long enough to be grandfathered. Is the buyer correct? It's possible. I don't know when the structure was built, and I don't know if they received approval from your association. It sounds like they did not. I don't know if this violates the county or the city's laws either. You know, there might be a setback violation or square footage violation, depending on, what the code says. If a violation has existed on a property for more than 3 years, we may be waived from enforcing it. So it sounds to me, based upon, what I'm hearing now, that that's a possibility. You're saying that the lot's for sale. I think it can't hurt to disclose to the buyer that, hey, this violation exists. And so at least the buyer knows that this is a violation. I'm not saying that you can enforce it. I'm just saying it might be a good idea to disclose it to the buyer so that they're aware that this is an ongoing discussion between the owner and the association. Okay, next question is from a board, number 31. If an owner resident lets a family member and or friend stay in his unit for a month rent-free, is the unit considered a rental property? So short answer on that would be no. If somebody's allowed to stay there for free, there's no money being exchanged, then it is considered a rental property. Okay, next question, number 32, from a board member. On April 2nd, our HOA board president sent out an email blast through our management company to our homeowners with the agenda for the regular board meeting scheduled on April 8th, 2026. The other board members were not given the opportunity to review and comment on the draft version of the agenda before the final agenda was sent out. Just so you know, that's kind of typical of how things work. The management company will maybe do the draft agenda, the board president will fine tune it and approve it, and then it's sent out. I mean, other than the time that I was the president of our association, which by the way was the longest year of my life, I would say I've never approved the agenda for any of the boards that I've been on. So this is pretty common practice. Now you're saying we want to add agenda items or edit the items on the agenda. Can the agenda be amended 48 hours prior to the meeting start? So I think that you need to discuss this as a board at your meeting. Of course, you can request that. It's only April 3rd and the meeting's not until the 8th. So we've got, the 48 hours we're well within that window. So at this point, I would say, ask, hey, can I have these items added to the agenda or whatever? Or I want these items changed and why. And ultimately, the president is going to make the decision on that, okay? That's one of their responsibilities, in my opinion, as the president of the association. Hopefully, the president is open to advice and, is willing to add some of these things to the agenda. If they aren't added to the agenda, you can talk during the homeowner forum, if your board has one, about the issues that you wanted added to the agenda, or maybe you can bring it up under new business at the meeting. But going forward, your board, you need to come up with a protocol for how you're going to handle the agenda. In my experience, typically the president just makes the agenda with the consultation with the management company. If you want to have other board members being more active in creating the agenda, you need to talk about it as a board, and you need to have a majority vote as to how the protocol is going to be handled going forward. Okay, question number 33 from a board member. What are the requirements for a special board meeting? Advance notice, 10 days to the owners, number of board members required to request a meeting, agenda requirement, etc. Okay, this is from a board. So you're asking, we want to have a special meeting of your membership for your association. And so how that works under Arizona law is that typically you have to look specifically at the statute, but the board typically can notice a special meeting of the membership. So the board can make the decision to have a special meeting of the membership. I believe also the president has the right to call a special meeting of the membership too, but I'd have to go back and double check the exact language of the statute. Also, you want to look at state law for how many of the owners would need to sign a petition asking for a special meeting of the membership. I believe it's 25%. Off the top of my head, I think it's 25%. You also want to look at what are your documents. Typically, this will be in your bylaws. What do your bylaws say about a special meeting of the membership? And you may need to comply with what your bylaws say also. State laws notice is you have to provide notice of a special meeting of the membership at least 10 days in advance of the meeting, but not more than 50 days in advance of the meeting. And that notice can be by U.S. mail or hand delivery. Let's see, the number of board members required to request the agenda. I'm going to have to look that up. I think it would just be a majority of the board, and then I think the president has the right to call a special meeting of the membership. You should send out an agenda when you send out the meeting of the membership, the notice at least 10 days in advance of the meeting. I think that would be best practices, and then also have an agenda available at the meeting. Okay, question number 34 from a board member. Homeowners often submit payment for fines and fees electronically. Perhaps they bundle it with assessments to pay their outstanding balances. However, the property management company won't apply any part of the payment to fines and fees unless the homeowner provides written direction. Although there is nothing that tells homeowners to do this, is this the correct interpretation of the statute? Seems like fines and fees would be paid after that month's assessment if the payment is sufficient. We just actually did an opinion letter on this for a different client. And so yes, the management company is interpreting that correctly. How the payments are applied typically based on state law is if someone makes a payment, if the owner specifies specifically how it needs to be, paid, you have to apply it that way. So if they say, I'm making a payment of $1,000, this needs to go to the fines, the management company should be applying it that way. If they just make a payment through the online portal of $1,000 and there's no indication how they want it applied, then it gets applied to the principal first that's owed and then interest. And the order that the principal that it's applied is going to be to assessments and then late fees and then collection costs. And so it's not going to automatically be applied to fines. So what you can do is if an owner makes a payment online and they intended to do it a certain way, but they didn't tell us, that it should be applied this way, you could ask them to send you an email asking that that payment on X date and the amount of blank be applied a certain way, and then you can go in and change it as an override. Question number 35 from a board member. Our articles state that the annual meeting must be held the first Monday in May unless it's a holiday, and then the next day thereafter. The bylaws state each May and the hour and the date decided by the board. It's not in the CC&Rs or rules. Our new management company wants to hold it at the end of May and says there's some new law that allows that. Can you help us clear this up? I'm not aware of the new law that they're talking about. The articles trump the bylaws in terms of, hierarchy of the documents, and the articles say it must be held the first Monday in May, unless it's a holiday. So my opinion is either amend the bylaw or amend the articles, take that out, or comply with it. And I'm not aware of any law that says that trumps, that particular information. Question number 36 from a board. Is it typical in the industry for condo unit owners to be financially responsible for repairs the HOA does in limited common elements? For example, in the condo HOA where I reside, both our condominium declaration and rules and regulations define limited common elements and say homeowners are financially responsible for repairs to limited common elements. And the HOA is to make the repairs, including selecting the vendor. Balconies are specifically referenced to be a limited common element in the declaration. Look, when you give the example of the balcony, I do think this is typical because we can't have owners making, random repairs to balconies that may not be, done by a licensed and bonded contractor. So it is very common that to have this type of provision in your documents talking about like a limited common area like a balcony, and that the association would need to select the vendor, do the work, and then they charge it back to the owner. So that is something that is pretty typical in my experience. Question 37 from a board. Is it legal to require that the HOA board may not meet without the property manager present? This is stipulated in the management company contract with the HOA. Also, who should run the board meetings, the manager or the board president? Okay, this is a great question because I think this kind of highlights something that is not good. So the management company should never have in their contract, I think this is not a good thing, that the board can't meet without them being present. That is, we're losing sight of who the boss is here. The association's board is the boss, or we are the representative of the association that runs things. The management company works for the board. It's kind of like it's not a good situation because when would the board want to meet without the management company? Let's think about this hypothetically. When they're not happy with what the management company is doing, or they're going to fire the management company, or they're going to hire a new management company. So this is a control issue with the management company, and they're putting it in their contract that, hey, you can't meet unless we're there. So it's kind of like an extra hurdle for the board if you ever want to fire them. So if I had reviewed that contract before you signed it, I would have said, take that out. That is not consistent with industry standard, and this is an attempt by this management company to control the actions of your board, and I don't like it. Also, same thing, control. The board president should be running the board meetings, not the manager. Now, on occasion, if you have like a new president who is not having any experience in running meetings, maybe the manager helps for the first meeting or two just to kind of get the feet wet of the board president, but this is not a long-term thing. The board president is the person that should be running the meeting, not the management company. Okay, question number 38 from a resident. What can be done about the board and board members who spend community funds without community knowledge or agreement? So really, spending powers are decided at board meetings, open board meetings. So you would have to go back and look at the meetings to see if something is authorized in the board meeting. So it's pretty uncommon that the board members would just go and spend money without having approval at a board meeting. I don't, maybe not at your association, maybe they are doing this. So I would ask, if I were you, I would just ask for the meeting minutes for the last 2 years and kind of look through the meeting minutes to see what decisions were made on expenditures and projects and go from there. Now, typically, regular bills of the association, those aren't going to be approved every month, but they are going to be, when you go over the financials at the meeting, those will be shown on the year-to-date budget. But like on larger projects like tree trimming or, there's lots of workarounds here. Maybe the board approved the management or the landscaping agreement, and the landscaping agreement says that tree trimming is part of the agreement. So maybe the board voted to approve the landscaping agreement, and they don't need to approve each expenditure each year because it was already approved with the landscaping agreement. So I would go to a board meeting, I'd state your concerns and ask them, when these expenditures were voted on, if you have a question on it. Next question from a board member, number 39. Our board consists of 7 members. 5 of the 7 members have excluded the other 2 members of the board from almost all correspondence between official board meetings. At a board meeting, one of the 5 present said something, then asked if member X and Y have any questions. It's glaringly obvious the other 5 have already discussed the topic. Isn't a meeting of more than 3 members considered a quorum and trigger the open meeting requirements? So short answer is yes. I don't know that you have the proof at this point, based upon what you've told me, that the 5 are meeting outside of the board meeting. They would all have to be, quorum of the board would be 4, meeting outside of the meeting discussing association business. You'd have to be able to prove that. Now, sometimes the president or maybe another board member, they talk to another board member about an issue before the meeting. That's not a violation of the open meeting law. So what recourse do the 2 board members have? My advice to you is raise the issue at an open board meeting and say, we're concerned that there are discussions occurring outside of the board meeting and we're not being included in them. And we feel shut out of the process, and see what kind of response that you get. Question number 40 from a board member. Looks like we have a total of 46 questions, so about 6 more. Do homeowners need to sign a release to be a part? Can put out a directory of owners with their approval of the homeowners. Owners typically aren't asking for that kind of a directory. What they are, let's see, I'm getting a little note that we're having some network issues. Should I switch to? Okay, sounds like our network issues have been resolved. Today's been technology issue day today, so glad we can roll with it. Okay, so the question is, just in case you didn't hear it, do homeowners need to sign a release to be a part of the association directory? So short answer is, if it's just their name and their address at the property, no. If you're going to include their email and their phone number, then this is something that the owners would need to agree to. So they would have to opt in, so to speak. I'm not sure that release is the right word, but they would have to opt in and give us their information, and then understand when they opt in that this is going to be distributed to the entire neighborhood. Okay, next question, question 41 from a board member. Our community has lost confidence in our property manager. What is the best way to go about replacing her? So we have a cheat sheet on selecting a management company, which I think could be a very useful resource for you. You can find that cheat sheet on our webpage at mulcahylawfirm.com. Just go to our cheat sheets tab and it'll be right there on selecting a management company. So how do we handle it from this point? So I would get a copy of the contract between the management company and the association, and I would reach out to your attorney. Hopefully your attorney is independent and not have any ties to the management company. I want you to know that our firm has any special relationship or ties with any management company. And therefore, if you reach out to us, I am not going to be breaching your confidence and letting the management company know, that there's an issue. I am your attorney and I am advising you solely. So be careful on that, because that is not always the case in our industry. There's lots of connections between different, actors in our community association industry. So what's the best way to go about replacing the management company or the manager? So it depends. Do you want to get rid of the manager, or do you want to get rid of the management company? If you want to just get rid of the manager change, you should go to the CEO of the management company, or if there's like a manager of managers, you should go to that person and say, we're done with this manager, we want a new one, and give the reasons why, and ask them to give you a couple candidates for people and talk about a transition plan. If you don't want to do that, you just want to get rid of the management company, you need to get the copy of the management agreement and reach out to our firm. We can help you determine what the procedure is to terminate the management company, and we can give you some suggestions on who would be a good fit for you going forward as a management company. Question number 42, our bylaws allow for a board member to give a proxy to another board member. Indicates that there's a form that needs to be completed. Do you have a standard form? So short answer on that is no, and I do not think that that is something you can do under Arizona law. So I would advise against your board from giving a proxy to another board member. I also think that under Arizona law, proxy voting is only allowed during declarant control, so it also would violate Arizona law. Question number 43, so we just have 4 more questions from a board member. We have some homes that do not meet the 324 box tree requirement in front. We have a homeowner who wants to remove 3 large palms in front of their house and is trying to claim that the pygmy palms that are left are fulfilling the requirement, which does not by definition. I think we need to tell them that they have to maintain the 324, I think it's 24-inch box tree requirement, so that they would have to replace it if they want to remove the large palms. How vigorously do we need to try and enforce that standard that is in our design guidelines and community rules? I think it is important. If somebody wants to take out 3 trees in front of their house, and they're trying to claim that the smaller, pygmy palms fulfill the requirement, I'd have to see the pictures to give you my honest opinion. But I think if you have a requirement to have 3 24-inch box trees, you really do need to uphold that requirement. If you don't want to uphold it anymore, then you need to amend the design guidelines and the rules. Okay, next question, number 44 from a board. We will be discussing design guidelines for fascia lighting at our April board meeting. Several homeowners have installed fascia lighting without requesting approval. So I'm guessing this is like this permanent lighting issue that we're seeing a lot of questions on now. Some of these homeowners set the lighting to be very bright or flashing. We are going to discuss what guidelines we should consider, perhaps hours of operation, illumination levels, or whether flashing should be considered. Do you have tips on creating a lighting policy? So we have a permanent lighting cheat sheet, which we have created on this topic on our website. And we have a blog on a policy for permanent lighting coming soon. So you definitely want to subscribe to our Mulcahy memos, which we send out twice a week, every week, and we will be giving out a free policy in the near future, or a free blog that will be discussing the policy in the near future. If you want to be added to our Mulcahy Memos mailing list, you can just contact us at info@mulcahylawfirm.com and ask to be added to our Mulcahy Memos list. That way you'll be the first to know when we send it out what, our memos have a different topic twice a week, and you'll be the first to know about it. Also, we always are posting our cheat sheets and blogs on our website as well at mulcahylawfirm.com. Okay, next question is from a board, question number 45. Our CC&Rs do not establish board eligibility requirements beyond ownership of a unit. Arizona Corporation Commission has updated its annual report requirements to include attestations regarding felony convictions and corporate bankruptcy. In response to prior financial fraud, the board of directors adopted a code of conduct requiring all directors to sign the policy and requiring directors and officers to provide identification, such as a driver's license or passport, and disclose any felony convictions or bankruptcy status as a condition of serving on the board. Is this type of code of conduct and related information reporting enforceable? Well, if a majority of your board adopts this code of conduct, yes, I do think it's enforceable. If it's challenged, I think that you have a good argument that we have to fill out the Corporation Commission paperwork every year. This is a question that's on the Corporation Commission paperwork. We have to disclose it. And we're just complying with that by requesting that information up front. So I don't have any issues with it going forward. Okay, last question of the day from a board member. My garden chair claims he can't work with the residents that volunteered for the landscape committee. He's therefore not moving forward. He's therefore not moving forward at all to get needed new trees and plants. We're a board of 3. What should the board do? So it sounds like you have a chair, you have a committee for landscaping, it sounds like, and this person who's chairing it can't work with the residents that volunteered for the landscaping committee, and therefore they're at a stalemate. I think the board needs to have a meeting with the entire committee, the garden chair and the other committee members, and find out what's going on. And maybe the president meets with them and try to determine who's being reasonable, who's not being reasonable. And maybe, we need to change up the lineup on the committee or change up the lineup on the chair. We can't let personality conflicts hinder the board or the committee from getting work done. So my feeling is either you work together as a team or you aren't on the team anymore. Okay, so that's it for today. We had a great class, about an hour and 34 minutes. We had 108 viewers at peak, which is amazing. This is probably a record for our first Fridays. So thank you so much to all of you who are here today. Have your questions answered. I want to let you know about a couple more different classes that are coming up this month that you may be interested in attending. So we have our 2026 Virtual HOA Condo Academy, our 4th class of 2026 on Tuesday, April 21st, 2026. We will be on Zoom and Facebook Live from 11 a.m. to 12 a.m. on April 21st. And this is a class that we teach every month in conjunction with the different municipalities and neighborhood services departments around the entire valley. And this class is going to be a great class. We're going to be talking about board ethics. We're going to be talking about how to prevent fraud in your association. We're going to be talking about board responsibilities with regard to finances, with regard to conflicts of interest, with regard to dealing with dicey situations pertaining to homeowners. And so we're really going to give you the tools to improve your toolbox as a board so that you are complying with your fiduciary responsibilities to the association. We're going to talk about some real life dilemmas that have faced associations and what are some suggestions on how to navigate those different problems or dilemmas. And we're going to talk about using a code of conduct as a way to ensure that your board is acting in a professional and legal and fiduciary manner towards your association and your association members. And then last but not least, we're going to talk about how to prevent theft and fraud of association funds, which is a very serious issue pertaining to many associations. Our next First Friday is going to be Friday, May 1st, and we're going to be on Zoom and Facebook Live to answer your questions live between 9 and 10 a.m. on that date. So look forward to seeing you hopefully at our April HOA Academy on April 21st or at our next First Fridays on May 1st. So thanks again for being here today. Happy Easter, happy Passover, and have a great month of April. We will see you soon. Take care.